Welcome to this episode of Term Talk, the Federal Judicial Center's video podcast discussing this term's Supreme Court opinions likely to have the most impact on lower courts. I'm Jim Chance, Senior Judicial Education Attorney at the Federal Judicial Center in Washington. We're going to discuss two cases, U.S. versus Skrmetti, a case alleging sex discrimination in healthcare, and Ames versus Ohio, which concerns alleged Title VII employment discrimination. I'm joined by Erwin Chemerinsky, Dean and Jesse H. Chopra Distinguished Professor of Law at University of California, Berkeley Law School, and Tara Grove, Professor and Vinson and Elkins Chair in Law at the University of Texas at Austin School of Law. It's great to see you both. Erwin, the plaintiffs in Skrmetti are challenging a Tennessee law that prohibits gender-affirming care in minors that's inconsistent with their sex at birth. The issue before the court, though, was the level of scrutiny to apply in the case. Sex discrimination cases, as you know, generally receive intermediate scrutiny, whereas the discrimination not based on sex receives only rational basis. Can you take us through the facts of this case, please?
As you pointed out, Tennessee adopted a law prohibiting gender-affirming care for transgender youth. This prohibits transgender youth from being given puberty-blocking hormones or cross-sex hormones. Tennessee is one of 27 states to adopt such a law. The legislative history said that this is about having children appreciate their sex and having a gender identity that corresponds to their biological sex. The United States District Court declared this unconstitutional. The District Court used intermediate scrutiny because it's sex discrimination, according to the judge, and also the District Court used intermediate scrutiny saying that discrimination based on gender identity should receive this level of review. The United States Court of Appeals for the Sixth Circuit reversed. The Sixth Circuit concluded it was neither sex discrimination nor that discrimination on the basis of gender identity should get intermediate scrutiny, and the Sixth Circuit emphasized deference to the Tennessee legislature. The United States Supreme Court, in a 6-3 decision, affirmed the Sixth Circuit and upheld the Tennessee law. Chief Justice Roberts wrote the opinion for the court, and much like the Sixth Circuit, really stressed the importance of deference to the political process.
Tara, can you explain the court's reasoning, please?
Right. So the court said this was not a classification on the basis of sex. It was also not a classification on the basis of transgender status. The court did not say whether a classification on the basis of transgender status would get heightened scrutiny. They just said this is not one. Instead, the court said this is a regulation of a medical procedure. And that's all that Tennessee is doing for people under the age of 18, so kids. They're preventing certain kinds of medical procedures for certain purposes. So the legislation, as the court put it, prohibits puberty blockers and hormones to treat things like gender dysphoria, gender identity disorder, gender incongruence, just medical procedures. Now, many listeners may be thinking, but don't these medical procedures only apply to transgender people? And doesn't it mean that if you are a biological female seeking testosterone that you'll be treated differently from a biological male? The court says, no, this is about medical procedures, even if those medical procedures only apply to a particular group. And the court relied on a case called Geduldig versus Aiello, which was a challenge to a law regulating that related to pregnancy, challenging it as discrimination on the basis of sex. And what the court held in that earlier case was that even if the regulation is about pregnancy, and even if it is true that women are the ones who become pregnant, it's not all women. And so the law really distinguishes between pregnant persons and other folks.
Erwin, Justice Sotomayor, Kagan, and Jackson dissented from this opinion. Talk to us about what they said.
Justice Sotomayor wrote a vehement dissent. She says, first, this is sex discrimination. She says there's drugs that be given to boys for reasons of affirming their gender that can't be given to girls, and drugs that be given to girls for that purpose that can't be given to boys. So, for example, imagine a boy is having delayed puberty. He can be given testosterone, but if a girl wants to transition to male identity, can't be given testosterone for gender-affirming reasons. Same thing, if a girl has delayed puberty, she can be given estrogen, but a boy can't be given estrogen. She says to restrict the administration of drugs on the basis of sex in that way is the very essence of sex discrimination, and therefore intermediate scrutiny. She also says this is gender identity discrimination. The whole purpose of the law is gender identity discrimination. Justice Kagan wrote a dissent emphasizing that as well. And here Justice Sotomayor says, essentially, Geduldig is one of the most ridiculed decisions in history. She quotes Justice Ginsburg that it was wrong when it was decided. She says this is discrimination based on gender identity, and she would use intermediate scrutiny for it. And I think that the difference between the majority and the dissent as to the level of scrutiny is what's key. The majority says, since it's rational basis review, we just defer to the judgment of the Tennessee legislature. The dissent says, no, this should be intermediate scrutiny, and we need to do a searching inquiry, and the evidence doesn't support prohibiting gender-affirming care.
So let me ask both of you this. What should the lower courts take away from this?
So I think one really important thing about the case is it's actually fairly narrow. Now, it's very important for many, many laws that regulate these kinds of treatments for kids. It's going to make it very, very hard to bring an equal protection challenge to those laws. One thing that the court did not even grant cert on, is whether a parental rights challenge in those cases could potentially work. So if a parent says, as a matter of my care and custody of my child, I believe that my child should be able to get these treatments, those kinds of challenges are still open, at least in federal court. So that could still happen. I also think it's really important that the court left intact its earlier holding in Bostock versus Clayton County that Title VII's prohibition on sex discrimination bars discrimination in the employment context on the basis of sexual orientation or gender identity. So in that context, it is still the case that discrimination on the basis of sex encompasses that kind of discrimination. The court distinguished Bostock and said the reasoning of Bostock does not necessarily apply to the Equal Protection Clause, but left Bostock intact in the statutory context.
I agree with Tara. I mean, as your first point, one of the issues presented in this case, though not decided by the Supreme Court, is this interference with the right of parents to control the upbringing of their children? If the parents, the children, the doctors want this care, does it infringe a right that the Supreme Court has recognized for over a century in terms of the right of parents to make the key decisions with regard to their children? That still has to be litigated. Certainly agree with Tara in terms of the court does not in any way undercut Bostock, at least in the Title VII context. One other thing I'd add to what she says, and we've talked about that, the Supreme Court does not decide what level of scrutiny is to be used for gender identity discrimination. Chief Justice Roberts' opinion leaves that an open question by saying there wasn't gender identity discrimination here. Justices Thomas, Alito, and Barrett write concurring opinions saying they think it should just be rational basis review. But the question is open. The Supreme Court has granted review in two cases for next term, Little versus Hecox and West Virginia versus BPJ, that involve state laws that prohibit transgender youth from participating in sports teams that correspond to their gender identity. So the issue of transgender rights, the level of scrutiny for discrimination against transgender individuals, will be back before the court next term.
Understand. All right. Tara, Ames versus Ohio was about discrimination against a member of the majority, a heterosexual woman. So what did the plaintiff allege in that case?
So the plaintiff alleged that she was denied a promotion that went to a lesbian woman, and that another job that she wanted went to a gay man, and claimed discrimination on the basis of sexual orientation. Once again, Bostock versus Clayton County is very important, right? Because in that case, the Supreme Court held that Title VII's prohibition on sex discrimination applies to discrimination on the basis of sexual orientation. But what the lower court found is that when a member of the majority, that is a heterosexual woman, is making the complaint, that plaintiff needs to show a lot more than a member of a sexual minority. And that was the claim that went up to the U.S. Supreme Court. Is there a greater standard for such a plaintiff?
This was an easy case for the Supreme Court. It was unanimous. I think it was predictable. The Supreme Court said that the same standards were applied under Title VII, whether the plaintiff is a member of a minority group or member of a majority group. And that had been implied by previous Supreme Court decisions, and that's what the lower court should remember in going forward.
Great. I appreciate both of you being here with us today. Thank you for participating.